People come to us often wanting to avoid probate at all costs, meaning they believe that probate is this horrific process that takes years or whatnot, and believe that they would be putting their family in a horrible situation should the family have to go to probate. Now, probate is certainly not a fun process, but it's also not the worst thing in the world. Sometimes there's information put out on the internet by people just trying to sell trust or try to sell extremely fancy estate plans, and in order to do so, they make probate look like this horrific thing. So I'm here to tell you the truth about what happens in probate in Florida. Right? So for starters, the length of time. Right? The average probate takes somewhere between 8 and 10 months. Right? And what that means is from the moment that the probate petition is filed until the time that it ends, on average you're looking at somewhere in 10 months. Sometimes a little bit faster, or it could actually be much faster in what's called a summary probate. Describe that difference in a moment. Right? But a huge chunk of that time, about 3 months of that time, is simply just waiting for what's called the creditor period. Right? So when a probate is first started, right, it's started by the filing of a petition for administration. That's where a person comes forward, and typically with a lawyer, they'll file this petition with the court, opening the probate estate and asking the court to do a few things. The petition asks for the naming of a personal representative, so who's going to be the person in charge of the probate estate. It tells the court who the decedents, the person who has died, telling the court who the family members are, whether the person was married, they have children. If there's no spouse or children, then who else may stand to receive the inheritance. It could be siblings or whatnot. It tells the court whether there's a will or not. And then it gives at least an initial estimate as to what the decedent's assets were, right? Whether they had a house, business, investments, or whatnot. And so then that person will give notice to the different people who could inherit, and the court will then appoint a personal representative, right? So if nobody objects, right, if none of the people who could be a personal representative or could be a beneficiary, if nobody objects, then in a short time, maybe 20 or 30 days later, the court will appoint the personal representative. If everybody agrees to that petition, if all the beneficiaries say, yes, the petitioner, right, I join in and I agree to what they're doing, if everybody joins in, it'll actually be much faster. You don't even have to wait the 20 or 30 days. It could be within a week or two. So once a personal representative is appointed, often they are going to do a couple of things simultaneously, and a lot of it's the work of the probate attorney, but they're going to issue notices to creditors. And there's two types of notice. There's going to be direct notice to any known creditors, right? So if the decedent had an American Express, a loan with Chase, and a student loan, let's just say, right? Well, you'd give direct notice to those three institutions, and because they got direct notice, they would have 30 days in order to file a claim. Now, if they do it within the 30 days, there's a chance they might get money. If they do it on day 31 or later, they are barred, meaning they're out. They're not receiving anything. Because we're not going to be absolutely sure as to every single debt the decedent had, we also publish notice in a newspaper, right? So if you've ever seen in a newspaper, they have like these notices, typically long and skinny, advising of the fact of this probate. That's typically done to give notice to creditors. And so any of the creditors that did not receive direct notice, they would have 90 days to file a claim. If they do it within the 90 days, then they might get paid. If they do it on day 91 or later, they're out. Another one of the things that the personal representative is doing during that time is making sure that they're finding all of the decedent's assets, right? So making sure that every house, investment, bank account, everything that the decedent has, it's going to go through this probate process, that it's all accounted for, right? And it's also maintained. Right? Want to make sure there's no like squatters living in the house, that the business is being run, that the investments are not being stolen or whatnot. Right? Just making sure that everything is accounted for. And then once that creditor period is over, so let's just say a few of the creditors file claims, personal representative might object to the claim for any number of reasons. And once everything with the creditors is sorted out, the remainder of the probate estate is then distributed out to the beneficiaries, right? So all in all, Again, this process typically takes between 8 and 10 months. There's often a push to make sure that it's done before, in less than a year, but there are some things that can make it go beyond a year, right? So, for example, if the decedent, if they were in the middle of a lawsuit, right, whether they were the plaintiff or the defendant, that kind of thing could necessarily require that the probate estate stays open for longer. If somebody makes a challenge to, let's just say the decedent had a will, and somebody's challenging whether that will is valid or not, then that can make the process go longer. So those are some of the major reasons why a probate estate might take longer. Something might just be if the personal representative isn't doing their job, right? Which is something that courts, they try to make sure that it is done by making sure that the attorneys, right? So you can get what's called an order to progress case, where the probate judge is telling the attorney, hey, you attorney, you have an obligation to move this case along. And so we obviously, at our firm, we try to make sure that we never get those, right? So, but it could happen for any number of reasons. Again, if there's litigation going on or whatnot, that can come up. So all in all, probate, it is a process. It's a court process, and coming on the heels of losing a loved one, nobody wants to hire an attorney and get involved in a court process. So I'm not here to say that going to probate is a fun thing and everyone should want to do it. Absolutely not. But just to say that it's not the worst thing in the world, right? It is just that. It's an administrative process. Just because a probate estate is open does not mean that necessarily you're in litigation. It just means that because of the way the decedent owned their things, that there's this process that where a judge is going to make sure that everything is done in an orderly fashion. So if you want to discuss whether you should create an estate plan that avoids probate or whether that's something that you would accept as part of your plan, please feel free to reach out to us. You can call our office at 305-359-3888. And of course, our consultation is completely confidential. You can be open and honest with us about your goals, your family, your assets, what it is that you're trying to accomplish, and we can help as best we can, give you the advice and the guidance so that you can make the decisions for yourself and your loved ones. Thank you.